Good morning. Is it Ms. Plunhumer?
Yes, Provencal.
Good. Good morning, Ms. Plunhumer.
Good morning, Your Honor.
You may proceed.
Thank you. May it please the Court, I'd like to begin by introducing my co-counsel, Young Sujo and Victoria Poulos, who are here in the courtroom. And also here this morning are the Provencals who have brought this case. This case raises important issues of first impression regarding the recently created Health Reform Act and the state-subsidized health care program, Commonwealth Care, as it affects low-wage workers. And the Provencals have been without health insurance for the last 2 years, and they are denied access to Commonwealth Care for the sole reason that Mr. Provencal's employer offers insurance that meets minimal contribution levels, but all the parties agree that that insurance is unaffordable to them. The question for this Court is whether the statutory language providing that the connector may waive the exclusion due to employer-subsidized insurance requires the agency to afford the Provencals an opportunity to be heard on their waiver request.
Now, am I correct that the waiver has never been granted to anyone, ever?
That is correct. In the years since health reform was enacted in 2006, there have been 0 waivers granted, and since the filing of this complaint, the connector has acknowledged that they have not implemented any procedures or process for considering waivers.
Does the record tell us how many applications for waiver have been made, or you say, okay, they've never granted it, but does that mean they've had 10 applications or 100 applications?
You raise an interesting question, and this is, of course, a motion to dismiss, so we don't have a factual record, but we are not aware of any other requests because, of course, the connector has not made it known that such a waiver exists. So there's been no notice to persons who are denied Commonwealth Care due to the availability of employer-sponsored insurance at minimal levels. There's been no notice provided to those people that they might apply for a waiver.
I just want to back up one step to make sure I understand one factual point here. As I understand it, the employer's group health insurance plan would cost Mr. Provencal $426 or thereabouts per month.
Yes.
And he cannot afford that. If somebody in exactly the same circumstances as the Provencals, except that their employer, but for the fact that their employer offers this plan, could they, is there another health plan within the Commonwealth of Massachusetts that they could buy for $426 a month or thereabouts?
I'm not sure if I understand your question about another health plan, but let me see if I can parse this out a bit.
Yeah, but just let me say one thing. What I'm trying to understand is there somebody out there who would be entitled, somebody in the same circumstances as the Provencals, but for the fact that their employer offers this to them? Would a family in their same circumstances otherwise be entitled to get the connector or Commonwealth Care?
Absolutely. So the connector has determined that what a 2-person household at the Provencal's income level can afford is $78 per month. So, but for the provision of this employer-sponsored insurance, that is the amount that they would pay, and they would be found eligible for Commonwealth Care. So they would get the insurance through Commonwealth Care.
Even though they could buy, if they could afford it, or if they could scrimp, even though they could buy some health care plan out there that is available for $426 a month.
Well, because they've been found to not be able to afford $426 a month. They've been found to be able to afford $78 per month.
All right.
In fact, if I might just use that example a bit further, if Mr. Provencal's employer didn't offer the insurance, then clearly, I think we would all agree, he would be eligible for Commonwealth care.
Can I just interrupt you right there? Isn't the purpose, at least one way of looking at the purpose of the statute that's at issue here, to provide for, not to provide for affordable health care, but to provide health care insurance for those people who, regardless of whether or not they can afford it, simply don't have access to it, either because they are unemployed or because their employer doesn't have a health care insurance, or because they are sole, they are sole employers, self-employed, and so on and so forth.
I believe that the statute, with its multiple interlocking pieces, meant to provide meaningful access. And that is the way to...
And the difficulty that I'm having here is that regardless of whether may means must make some available and you have individualized health care, there are, for example, very, very, very severe consequences of not having dental health care. Very severe consequences. Now, you can buy dental health care, but it is expensive, and it doesn't always cover everything and may not, in fact, cover the illness that you think you have, or there may be a pre-existing. I mean, essentially what you are asking us to say in connection with your particular clients is that the connector has to have an individualized hearing on whether they can economically afford the insurance that is available to them to cover the kinds of illnesses that they or their family are likely to have.
I don't believe that is what I'm asking this
Why
court
not?
to find, because the connector has already found that they cannot afford this health insurance, and that's why they are not subject to the individual mandate. That's why they've been excused from purchasing this health insurance, because they cannot afford it. They've been found to only be able to afford $78 per month. And I believe it's correct, Your Honor, that what the legislature was doing was balancing competing both incentives and responsibilities.
Yes, because I don't know how we make I understand that the connector, for purposes of not concluding that somebody is liable under the statute for not getting health care, that's a different determination. But how we can make an individualized determination where, for example, you have a married couple and one of the spouses decides not to work because they think it's preferable to have somebody stay at home to look after a 12-year-old child. Are we supposed to say, well, taking a look at their income, they can't afford it? I mean, it seems to me that you're missing the point of what the statute is designed to do.
No, and I believe that the connector has the authority to develop additional waiver criteria to deal with some of the policy and fiscal implications of saying that the exclusion due to employer-sponsored insurance must be tempered by some individualized determination.
But they say no. If there's their regulations say if there's employer-sponsored insurance, that's the beginning and the end of our discussion. We're not going to get into the tempering, because that gets the connector into all kinds of individualized hearings that don't go to the underlying, thrust of what this legislation is designed to address.
But that would be to ignore Section 3B of the statute. That's exactly what the legislature did by putting that right in the eligibility provisions for Commonwealth care. They were saying, we are concerned about the effect of saying people who have access to employer-sponsored insurance, even at minimal contribution levels, which they cannot afford, will mean that low-wage workers are effectively barred from getting any insurance.
They were barred before the statute was enacted, correct?
That could be correct.
That's correct. So, I mean,
that's what they meant
without a connector, your clients couldn't afford health insurance, right? This is not a good situation to be in. Your clients couldn't afford health insurance. And the legislature didn't say any person who can demonstrate that they cannot afford the health insurance that their employer offers is entitled to an individualized hearing.
Well, I believe that is what the statute provides, because it says in repeated ways that the that the connector may waive the exclusion
It
if an
may, but it need
individual-
not.
Correct, which means they may in an individual circumstance and they may not in an individual circumstance. But
And
it
you're
should
saying
not-
that, and you're saying that the may includes a hearing, that there's no way of making a determination without a hearing.
Oh, I think there well could be. We're saying that there needs to be a process, but that ultimately it is part of the eligibility determination. And I believe that if this court agrees that it is part of the eligibility determination, that if it cannot be resolved through a paper application or some other process, that ultimately they would have a right to a hearing on
Aren't
that
you also
request.
saying that the fact that they've never granted a waiver suggests that it's really illusory, that there is no waiver process that they follow?
There isn't one. They acknowledge that there is no waiver process. And that's what we're saying the statute requires, is some process.
So,
And-
if there was a process, I mean, the reason you want a process is because then you have an appeal, and you can go to, if you're denied, you can go to a court under an administrative agency appeal. So how is the court to decide this?
The statute itself, Section 3B, provides the first set of standards that were listed, which is that the employer's health insurance must meet certain non-discrimination criteria.
Well, that's a given.
So assuming that
That's
it
not a
meets
standard
that,
with respect to individual eligibility.
then the way to read this statute is that the legislature left it to the connector to develop additional waiver criteria.
Connector just says can't afford it. Our budgetary appropriation is insufficient, can't afford it.
And
Is that enough?
no, I think the statute does not
And
permit that.
so it then says it may waive clause 4 of subsection A,
Yes.
right? And it says, at the present time, we have determined that we cannot have any such waivers.
And so
But that's by regulation.
yeah. So the question for this court is that what the statutory language meant? And we submit that it is not. And the reason it isn't is because when it listed the reference to the individual, it envisioned that there would be individual determinations, and that may means may or may not in an individual case, but it does not mean may never. And the other evidence of that, in addition to it being embedded in the eligibility statute, is that the conference committee report itself said this was what we thought we were doing in Section 3B. We thought that what would happen is that individuals who had access to employer-sponsored insurance but whose income fell below 300% of poverty would be eligible, but that their contribution from their employer would go to the connector. There was an intention that this be implemented.
What's the cite on that? You said the conference committee report.
It is in our brief at, I believe, pages 14 and 15. And it's also in the addendum.
What are the actual consequences to your clients for not getting the insurance?
Well, it's what it means to not get health care, Your Honor.
Well, is there an additional consequence to that? Do you
No, because they've been determined by...
do you forfeit your tax return or something like that?
Oh, no, because they have been found to be unable to afford health insurance. They are relieved of that penalty. In addition, the employer who's offering this insurance that they cannot access is also found to have met its fair share contribution, so the employer pays nothing. If you look at Section 3B, it goes on then in great detail about how the contribution should be collected and allocated. And it indicates that the actual insurance that the employer would have purchased and their contribution toward that employee's insurance would then be sent to the connector, as would the employee's contribution, which they're found to be able to afford. So in the case of the Provencals, for example, they would send their $78 in. The employer would send in its share, which, while not in the record...
So why isn't the Chief Justice's question the question that we should be asking? Isn't the whole purpose of the legislation one of access?
Yes, it is one of access, but it recognizes that access is a function of affordability, and that throughout the Act, it talks about access to affordable products. There's a series of creating incentives and responsibilities, and the Commonwealth Care Statute itself purpose is to reduce uninsurance. The exclusions, the people who can't get Commonwealth care, are primarily people who already have insurance. They have it through Medicare, they have it through Mass Health, they have it through Children's Health. Then there are two provisions that deal with people who perhaps don't have insurance. And the first is the one that's at issue in this case, where there's an offer of employer-sponsored insurance. And then the second one is where the employer has made a promise to, a deal to help get insurance.
We don't know from the record, I take it, how wide a group this is. The plaintiffs are representative of how many people? We have no idea.
That's correct. This is not a class, and I believe...
I know it's not a class, but we don't have
But
any
there is
idea.
declaratory relief, and I think the answer, Your Honor, is that the connector can shape the number of people who would be affected by making sure that it adopts waiver criteria that are perhaps more restrictive. This is not about everybody getting a waiver. And if you look at the brief of health law advocates at pages 35 to 37, it indicates, for example, that for people below 200% of poverty, there are perhaps 36,000 people who are uninsured, who cannot afford their insurance because it might cost them over half of their income.
But is this perhaps something, a next step that the legislature should consider or may not want to consider? Because it's really something going beyond what the current law talks about.
I don't
I know
believe
you
so.
say Section 3B.
I believe that this current law, with its request for a report on how it's being implemented and the very precise calculations as to how the money should be collected, planned that it would be implemented to address this serious gap in coverage for low-wage workers.
So if the connector could adopt waiver regulations that did not include everybody who can't afford insurance, and in fact, they could adopt it that would only include 1%
That's correct,
of people.
Your Honor.
Why isn't the decision they've made effectively the same as that?
Because they haven't exercised their discretion in the first place. And
But they don't have to exercise the discretion.
We believe that they do, that the statute with its may...
But let me put this, to follow.
Yeah.
If they adopted regulations that excluded your clients, right, would you be back here saying that wouldn't you be back here saying the regulations are irrational?
Well, if they were consistent with the statute and its underlying purposes and it didn't violate some other...
But you're
Its
saying
underlying
discrimination
purpose
law?
is that everyone should be covered. You're saying everyone who cannot afford it should, of course, get it.
The injury to my clients is a process injury. They have not had a chance to have their waiver considered. They received a notice indicating that it had been denied because there is no provision for a waiver.
No, I understand that, but I'm looking at the practical consequences. Essentially, as I said, I think it would be fair to anticipate that if there were regulations that in fact didn't cover your client, you would be in here saying these regulations are irrational, they're beyond the scope of what the legislature delegated to the connector because access is affordability and it's stipulated that my clients can't afford it. So in essence, you're saying we have to tell the connector to say anybody that you say meets the cannot afford it criteria for purposes of income tax reporting purposes is entitled to health care insurance under the connector.
No, that is not our position. Our position is that they can adopt more restrictive criteria, recognizing the fiscal and policy concerns that they have tried to inject into this matter of statutory interpretation. But they can consider those factors in adopting waiver criteria.
Thank you.
Thank you.
Ms. Pluenhuber. Mr. Valver?
Thank you, Your Honor. Let me start by addressing a few of the questions that have been asked already. Justice Cowan asked, do we have any sense of the size of the population of people who are 300% or below poverty level but who have employer-sponsored insurance available to them and people who decline that insurance for whatever reason. Usually it's that they can't afford it. The numbers that are stated in the report to the legislature that's attached to our brief gives a range depending on the assumptions that are made about the population, and that range goes from in the 50,000s to over 200,000. At the low end of that range, actually below what the connector has estimated, is the number that's offered by the amicus. That figure is 40,000. So we are talking about not a few people who are in this situation, and I have to say the legislature was not unaware that there is a population that this particular program, Commonwealth Care, does not reach. When Ms. Prunuber says that the statute was intended to address this population on issues of affordability, I think she's referring to the health reform law as a whole. There are many different programs and many different provisions. The affordability provisions are in 111M, and that has to do with the so-called individual mandate. It is not a function of eligibility for Commonwealth care.
Well, what do you say 3B, the reference to waiver, the board may waive clause 4, what does that mean?
It means exactly what it says. It may, or by implication, it may not.
So
but I will tell you why I think it's there.
Do you agree that the connector has never granted a waiver?
The connector has not granted a waiver. There have not been many requests. The waiver policy is known. There are materials on the
Am I right?
website
I think I read
that's
somewhere that now the connector is starting to grant waivers along the lines of what the plaintiff is talking about?
No, the board of and the staff of the connector have been exploring different programs, including a pilot project that might institute a waiver. That came up at a time when the budget situation was probably more constrained than it was when the statute was originally enacted. Affordability, let me just finish my prior point. Affordability, the word affordability does not appear in the Commonwealth Care Statute.
But under Section 2, it does have a plan for outreach designed to reach low-income, uninsured residents.
Correct.
Right? Now, this, presumably, the plaintiffs here are low-income, uninsured.
Well, they're uninsured. The definition of uninsured, both by regulation and clear statutory intent, is that uninsured means people who have access to insurance, whether they choose to accept it is a matter of that may be constrained by their finances, but it's their option. Commonwealth Care was designed primarily for people who do not have employer insurance available to them. That's why the legislature in 3A4 says you are not eligible for Commonwealth Care if your employer offers you insurance of meeting a certain standard. The waiver was inserted because, of course, the legislature, if the circumstances were appropriate, including the fiscal situation, allowed for it, there might be a raising of that threshold or a loosening of that exclusion to some extent. That waiver provision, the reason why it has no criteria, was to give maximum flexibility to the connector to determine when, how much, who, and for how long such a waiver might be granted. It's thinking in terms of legislative initiatives rather than whether a particular family walks in the door and asks for a waiver.
How can you say that Commonwealth Care statute was designed primarily for people whose employers don't offer their health insurance when the statute itself seems to provide the mechanism to take the insurer's portion of what they do pay and then...
In the event of a waiver.
Yeah.
But if you look at the eligibility criteria that are specified by the legislature, not putting aside the waiver, 3A4 says you are not eligible if your employer offers you insurance meeting certain criteria, period. It's that provision which is the subject of the waiver if conditions are deemed appropriate and the fiscal situation and other policy considerations, it's not just fiscal, permit a loosening, maybe on a pilot project basis or an incremental basis, the kind of thing that a legislature would consider approaching as a way of improving or extending benefits to a greater population. It was not designed to create an individualized entitlement to anyone who came in the door and said, look, I'm sorry, my employer does offer me insurance, but I just can't afford it. There are 40,000 other, at least 40,000 other people just like those. The connector has to adopt an approach to this which, in terms of equity, applies fairly across that board, although it may decide that some situations, some scenarios are more compelling than others. I want to say that the connector, it has been said that the connector has not exercised its discretion. By that, I take it to mean that the plaintiffs are saying that the connector has not implemented a program of individualized hearings and
Well, that's
and
what I was
waiver.
trying to explore, because
that's
if you
correct.
said the
Because
regulation said, at the moment, we're not doing any waivers, she'd be right back here saying,
Exactly.
no, and if you then did, well, we're only going to do the first 5,000, she'd be right back in here saying, but as to me, you're not achieving the affordability.
But what I want to add to that is that the connector has considered its Section 3B discretion.
Okay.
It has, in response to a specific directive from the legislature, which in November 2007 said, tell us what you're doing about waivers. The next year, in 2008, the connector submitted a report to the legislature. That's the subject of our motion for judicial notice. It's attached at the end of our brief. That report contains a discussion of a lot of different issues, the estimated enrollment increases, the consequent increase in cost, concerns about whether the federal matching monies would be available under the Medicaid waiver, concerns about the impact on mass health, because children of these families now get added into the mass health budget and off of the private insurance coverage, and the likelihood of disrupting the private market. This is the issue referred to as crowd out, where a publicly subsidized program is obviously going to be a lot more attractive to both employees and to employers, and as a consequence, employers may cease to offer private insurance, which is the backbone of the Massachusetts health insurance system, and upon which the health reform law must depend. If the private employer insurance market is eroded, then the entire ecology of health reform gets affected, and things start to unravel.
Does the waiver program, if you will, depend upon a specific appropriation from the legislature?
No, but if you look at Section 5 of the Commonwealth Care Statute, that requires a moratorium on enrollments of any kind, either eligible or by waiver, if the projected enrollments would meet and exhaust the amount in the Commonwealth Care Trust Fund. There is a fixed amount in the trust fund. It's projected for, on an annual basis, what Commonwealth Care enrollment would be and what it will cost. If the enrollments increase beyond that, the connector is mandated to impose a moratorium on any further enrollments, even by people who have no employer-sponsored insurance and therefore have no access to any kind of insurance.
When you say the trust fund, but I take it the trust fund is principally funded by a state appropriation, right?
Yes, it's not a direct line item. There's a convoluted way that the money gets into that trust fund, but it's a known number for think in our brief, we identify,
Well, if the number's exceeded, I take it an appropriation would have to be authorized to pay.
it would have to.
So these funds are state funds.
Exactly. In a sense, it's the, the Massachusetts governmental motto is subject to appropriation. All of these programs that are subsidized by Massachusetts taxpayers are, of course, subject to appropriation. But what Section 5 makes clear, Commonwealth Care is not an entitlement program. You can be categorically eligible for Commonwealth Care enrollment, but if we've hit the budget limit and there's a moratorium imposed, you are not going to get benefits.
Mr. Valvo, two questions
Yes,
for
Your
you.
Honor.
Back to 3B, the section that says the board may waive. You've never allowed a waiver, and your position is that in not ever allowing a waiver, you were exercising your discretion.
We exercise discretion in reporting to the legislature why it was inappropriate at this time
Which I
under
take
current
it, and
conditions.
I take it the short answer to that is because too many people will opt out of ESI plans into ComCare.
Well, there actually is not a short answer. There are many different short
at
answers,
least
but that's at least one of the problems.
Now, that follow-up question is Section 4 talks about a resident's right to receive written determination detailing denial of eligibility and the right to appeal.
Yes.
So when you deny the waiver, do you explain to the applicants we have exercised our discretion by denying the waiver, and then they have a right to appeal that?
They do not have a right to appeal that. That's not an eligibility determination. Section 4 applies only to eligibility determinations. The word eligibility in the statute, if you look at 3A, a person is eligible if they meet the following 5 criteria. That's what defines eligibility. The plaintiffs want to back into the eligibility criteria the waiver, which is both inconsistent with the text of the statute as explained in our brief, but it's also illogical. It doesn't follow that a statute which gives authority to waive an eligibility criterion becomes itself an eligibility criterion.
No, from your position, there's no appeal of the denial of the waiver.
Well, there is no appeal of the denial. That's right. In this case,
But there would be if you had waiver criteria.
if we did promulgate a waiver program with criteria for who is in, who gets a waiver and who doesn't, and the criteria implicates some disputed issue, yes, then an eligibility hearing would be appropriate and an appeal would be appropriate. But we don't have that. The statute doesn't supply any criteria. The statute doesn't mention affordability. The statute doesn't say upon a showing. It doesn't say upon a finding. It's not predicated on any fact that is applicant-specific that would go to some claim of entitlement to a waiver.
Is there any legislative history on waiver? What was the intent of the legislature when they said the board may waive Clause 4?
There's legislative history, but it doesn't really say much beyond stating the obvious, that the connector may waive. That's the language.
No explanation of what criteria or when or how or
No, it's
under what circumstances?
It says the legislative history that my sister referred to earlier, the conference report on page 15 of her brief. People who have employer-sponsored insurance may be eligible, but the employer must pay a portion of the premium cost. That doesn't speak. They may be if there's a waiver, but that doesn't speak to the individualized hearings and who gets a waiver and who doesn't.
Mr. Valvo, you make the case, in part, that what's at stake here is really a political question. The other side says, no, 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 this doesn't fit at all.
Absolutely, yes.
The criteria for a political question. Why is this a political question in your view?
It's a political question in the Massachusetts sense, not in the federal sense. This has more of an administrative law issue than a constitutional one.
All right.
The cases that talk about a political question note that where a statute gives discretion to an agency without judicially manageable criteria, or they include something like in the public interest or for the public convenience, such statutes don't give courts enough discretion, enough guidance to determine whether or not the discretion has been exercised in accordance with legislative intent. This is that statute. This statute says may waive, essentially without any guidance, restriction. You may waive, but then there's some consequences about collecting the money and all of that.
But if the question is whether that requires you to have a waiver process, why is that a political question?
Because for the reason that Chief Justice Marshall indicated at the beginning, may waive includes discretion not to waive. And where you have a considered exploration of the waiver issue, which I say the report to the legislature represents, and by the way, there have been follow-up initiatives to address the waiver, and each time the board has deemed it inappropriate to proceed at this time. But this is essentially, I say it's a political question also because the waiver provision in 3B is basically the legislature giving to the connector the ability to suspend an otherwise very specific, very calibrated eligibility criterion that clearly excludes people with employer-sponsored insurance.
It's a you're saying, I take it, it's a legislative, it's
sort
an
of
exercise of legislative power. It's not
Exactly.
an exercise of adjudicatory power.
Exactly. That's exactly right. The legislature has handed the connector the ability to suspend 3A4. That's basically what it is.
Could I just ask you two quick questions? On your waiver of claims portion of your brief, I gather that that the plaintiffs have abandoned their constitutional claims, but you still maintain that they claim that the connector must establish objective criteria beyond those found in the statute on which to base their waiver decisions, and they claim that 38 Section 14
Yes.
itself requires
Yeah.
those were waived.
Well, let me I believe that the argument about the obligation to promulgate specific standards is waived because it's not briefed.
Okay.
There's a little bit of a misunderstanding about the 38. In that footnote, I refer to 30A itself
Okay.
as being the basis for a claim. What I think the plaintiffs say is that 30A is imported into this process via Section 4. But 30A-14 itself does not grant any authority to do what they want. That's the way it was pled in the complaint, and I'm just pointing out that there's no independent reason under 30A-14. Thank you, Your Honor.
Thank you, Mr. Valbo. We'll take a short break.